Hello, everyone, and welcome. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society. Today, the Supreme Court Historical Society pays tribute to the 100th anniversary of one of the most significant developments in the history of the Supreme Court and the entire federal judiciary, for that matter. Most casual students of the Supreme Court and its history are well aware of the significance of the court's decision in Marbury versus Madison in 1803 and its affirmance of the court's and the federal judiciary's power of judicial review, that is, its authority to determine whether actions by the legislative and executive branches of our government are constitutional. Not as many of those students, and most Americans in general, are as aware of perhaps the second most impactful and defining event in the shaping of the court's work in our country's history, and that is the Judiciary Act of 1925, which was passed by the Congress of the United States. We're going to host a discussion today about the events leading to the passage of the 1925 Act and the sweeping changes it implemented to the great relief and appreciation of the Supreme Court. And we're going to pay appropriate tribute to this occasion with two of the country's most outstanding experts on the Act, Professor Robert Post and Daniel Holt. We're very excited about bringing the perspectives of both the judiciary and the Congress together today in this historic legislation and our tribute and celebration of it. Robert Post is a Sterling Professor of Law at Yale Law School. He served as the school's 16th dean from 2009 until 2017. He has written and edited numerous books, including The Taft Court, Making Law for a Divided Nation, 1921 to 1939, published in 24, which is volume 10 of the Oliver Wendell Holmes devise, The History of the Supreme Court of the United States. Dan Holt is the Associate Historian of the Senate, a post he has held for the last 10 years. Before that, he was also an Associate Historian for the Federal Judicial Center. He has edited volumes 2 and 3 of the Debates of the Federal Judiciary, a documentary history. Both bring expertise and great insight into this important act. Let's begin with Professor Post. And Robert, could you set the stage for us, please, by describing the work of the Supreme Court in the late 1800s and early 1900s?
Thank you, Jim. And let me say first what a pleasure it is to be here with both you and Daniel. So if you look at the Supreme Court of the United States as it existed, say, through 1890, it was established as an apex appellate court. So its jurisdiction was largely mandatory. You know the phrase, I'm going to take it all the way up to the Supreme Court. Well, people could take it all the way up to the Supreme Court if they had the time and, more importantly, if they had the money. And if your decision was decided in a state court and contained a federal issue, if it was decided in a federal court, you had a right to take the case up by way of appeal or by way of writ of error all the way to the Supreme Court. So the docket of the Supreme Court was basically out of its own control. And its status was as the highest court of appeals in the land. So it decided extremely important cases, but mostly the run-of-the-mill of its docket would be comparable to the docket of a court of appeals, say, of the Sixth Circuit or of the Eighth Circuit today in the United States.
And before getting into the specifics of the Judiciary Act of 1925, let's go back and talk about the Everett's Act and exactly what that was. It was formerly called the Judiciary Act of 1891, and it was intended to reduce the Supreme Court's caseload at that time by introducing new intermediate level federal appellate courts. And how did that legislation evolve? Dan?
Yeah, it's really important for this discussion of 1925 because kind of the groundwork of reconsidering what the role of the Supreme Court in the federal judicial system really begins in the late 19th century. And the context is that following the Civil War, Congress expands the jurisdiction of the federal courts more generally. And so you have more cases coming into the district and circuit courts, which were the trial courts at the time, and more appeals making their way to the Supreme Court. Just as a kind of some numbers, in 1860, there were 300 cases pending before the Supreme Court. By the 1880s, that number had grown to 1,200 cases. So there was this discussion that began about what should be done about this. And there were kind of two schools of thought leading up to 1891. One was that for especially Democrats and Southern Democrats in particular, they didn't like the idea that the federal courts were growing in importance. And they said the way to reduce Supreme Court jurisdiction was to reduce federal jurisdiction in general, bring it mostly to the state courts. Then on the flip side, there were other proposals to change the way the Supreme Court was organized. You had bills that would have one of which would have expanded the size of the Supreme Court to as many as 21 justices, and then would have been broken up into panels to hear particular kinds of cases in this period. Ultimately, neither of those were very satisfactory to the members of Congress at the time. They were wary of making anything that sounded like a radical change. And it really isn't until the situation grows to a head in 1890 that Congress opts for this option of creating an intermediate level of appeals courts. And to make those actually matter for the Supreme Court, they had to decide to make some cases more or less final in those new circuit courts of appeals. If you wanted to get to the Supreme Court for cases that came to the federal courts through diversity of citizenship, meaning the litigants came from different states, you had to get a writ. You had to apply for a writ of certiorari for the Supreme Court to take that case. It was up to their discretion. There were certainly other cases that remained obligatory for the Supreme Court, but this is kind of the beginning of that process where the idea that the Supreme Court should have at least some discretion about the cases that it hears.
Was there great controversy in the Congress about it at that time, and what were the issues that were some worried that it might diminish the importance of the Supreme Court?
Yeah, I neglected to say one of the proposals for reducing the number of cases was to essentially increase the cost that would be in dispute in civil cases to something like $10,000. And this very quickly, especially on the Democratic side in the House and Senate, gets derided as breaking off general public access to the highest court in the land. That by doing so, you would threaten to turn the Supreme Court into a rich man's court that would only cater to the powerful and to corporations that were really flooding the courts with cases at the time. Ultimately, they decide on different criteria. As I mentioned, cases from diversity jurisdiction are what are made final in the courts of appeals, but questions that are of a constitutional nature, they can actually go around these appeals courts and go directly to the Supreme Court. There was still that notion that the Supreme Court had an important role to play there. And questions dealing with like federal statutes, so-called federal questions, they would go to the courts of appeals, but you had an appeal as a matter of right to the Supreme Court. So that was kind of where, rather than deciding that it had to do with the cost or how much money was involved, they kind of chopped it up based on the basis of jurisdiction.
And the notion that the Supreme Court should be the final gatekeeper, was that one that was also debated, and was there concern expressed about that?
Yeah, there was, at this time, because there's so much delay in getting to the Supreme Court, there was concern that justice delayed is justice denied. And this carries through into the 1920s when they talk about the 1925 Judges Bill. But it was very important, they believed, that litigants can get to the Supreme Court and that they can get there in a timely fashion and that they can reach final adjudication of their cases at the Supreme Court.
Professor Post, the Everts Act did reduce the caseload at somewhat, and I think it was temporary. The justices ultimately ended up having an increased caseload with a backlog again. How did that happen, and what was the explanation for that?
Well, at the time of the Everts Act, the time between docketing a case at the Supreme Court and the Supreme Court actually deciding it was upwards of 3 years. So you would take a case up to the court, and you have to wait 3 years before the court would decide it. And the backlog was enormous at the court's level. And the Everts Act, even though it was extremely badly drafted, the court spent the next 30 years trying to figure out which cases could come directly to the court, which cases they could give certiorari to. The court could never find it out. In point of fact, Taft writes these memos when he's Chief Justice to his fellows, says, "I've spent the last 3 months studying this. I cannot figure out what that act means." McReynolds told me from the beginning I couldn't be able to figure it out, and he was correct. So this causes a lot of confusion. But one thing it does do is it reduces the backlog at the Supreme Court, and it reduces the delay between the time of filing a case and the time of deciding a case considerably, to the point where the court was, relatively speaking, concurrent with its docket. You could file a case by the next term, at least you would hear it. And the court was viewed from this perspective as a tremendously successful act, insofar as it allowed the court to resume normal functioning, the normal functioning of a busy court. And it kept that way for 15 years. But one can see, if one charts the cases filed and the backlog of cases, that the court began to fall behind on its docket again around 1905, 1906. By 1910, by 1912, when Taft is president, the backlog had built up considerably. It's not exactly clear to me why that's true. If you look at the numbers, there's not that great of an increase in filings. It looks to me more like the court was a lot less efficient in handling the cases that it had. But in any event, the court began to experience itself as falling behind, and there was great fear that it would end up falling behind to the extent that it had in 1890 before the Everts Act was enacted. And so legal reformers, of whom Taft was most prominent, began to take up the cause of giving relief to the Supreme Court. The first time I can find him doing this is 1905, when he writes an article saying we ought to reduce the workload of the court. But at that time, he's arguing that the court's workload should be reduced in order to diminish the expenses of litigation. Taft always believed that litigation should be efficient and cheap. He thought that the more expensive litigation got, the more it favored the wealthy, and that was a source of disaffection with federal justice. So he wanted federal justice to be cheap, and taking another appeal to the level of the Supreme Court made it more expensive. It made the poor litigants drop out, and the rich litigants, the corporations, able to take poor litigants over the barrel, and they couldn't afford the litigation. So we wanted to remove much of the mandatory jurisdiction of the Supreme Court for that reason. By 1910, when he's president and recommending changes to Congress in the jurisdiction of the Supreme Court, he's now articulating it as a crisis in the court itself. He's saying the court has too much business. It can't keep up with its own docket, and so we need to give it some form of relief. And for the next 10 years or so, he has different proposals for how to reduce the jurisdiction of the court. In 1914, after he's president, but he's president of the ABA at the time, he has a proposal saying we ought to reduce the jurisdiction of the court by requiring it to take only constitutional cases, and everything else it would be discretionary.
And what about the nature of the cases themselves, Robert? On the mundane nature of or describe for us, if you will, the kinds of cases they were hearing in those days too, in addition to the growing number and the backlog.
Well, I should add one thing before I get to that point, which is when Taft gets appointed Chief Justice, which is June of 1921, there is an enormous rise in the case level, in the docket, in the number of cases being filed there. And there are two major causes of that. One is World War I, because there's a lot of litigation about various adjustments over World War I. And the second, which is huge, is Prohibition. So, if you think about prohibition and the 18th Amendment, suddenly the federal government had become responsible for suppressing alcohol everywhere in the country. This is the most enormous increase in federal administrative presence since the Civil War. And no way that the federal government was equipped to do this. And so a lot of the activities, the enforcement of prohibition, gets thrown to the courts, which suddenly become like misdemeanor courts in an urban environment, and they are flooded and they are overwhelmed. And much of this litigation finds its way to the Supreme Court. So by the time that Taft gets appointed Chief Justice in June 1921, the court is beginning to experience a really deep crisis in its docket. It has far more cases than it can handle, and the delay between filing a case and hearing a case is anywhere between 18 and 24 months. So it's beginning to look like the Edwards Act all over again. This crisis is forming.
It's noteworthy, too, that in the 1891 Act, they actually specifically leave criminal and infamous crimes or one of the category of cases that can make their way to the Supreme Court. And it's somewhat controversial at the time, where people are saying this is going to actually lead to a lot of work for the court. And obviously, it's there, it's ever present. But yes, prohibition really ratchets up that source of caseloads, and it becomes a real problem very quickly.
So what you see when Taft becomes Chief Justice is you see a court that is overwhelmed by many, many different kinds of cases. The docket really looks like what we would now a court of appeals would look like. So I'll give you a concrete example of this. It's almost unimaginable for a modern observer. We now think of the court, if you ask anybody, what is the Supreme Court? Oh, it's this marble building. It gets the most important cases. Every case is so portentous for the country. It's going to change the nature of the Constitution. It's going to change the nature of environmental law. Whatever case they take, it's hugely important. That was not what the Supreme Court was in 1921 when Taft becomes Chief Justice. And I'll give you a concrete example of it. This is a justice named John Hesson Clark, mostly forgotten for justifiable reasons. But he's appointed by Woodrow Wilson in 1916, and he retires in 1922. And he writes a letter to Woodrow Wilson explaining why he's retiring. And he says this. I'm going to read the letter. I'll read a paragraph from the letter, if I might.
Thank you.
He's writing this to Woodrow Wilson. He says, "Unless you have much more intimate knowledge of the character of work which a Supreme Court judge must do than I had before going to Washington, you little realize the amount of grinding, uninteresting bone labor there is in writing more than half the cases decided by the Supreme Court. Much more than half of the cases are of no considerable importance, whether considered from the point of view of principles or of the property involved in them, but nevertheless, a conscientious judge writing them must master their details with the utmost care. My theory of writing opinions has always been that if clearly stated, 9 cases out of 10 will decide themselves. What the decision should be will emerge from the statement of facts, as certainly as the issues will. In this spirit, I wrote always. I protested often, but in vain, that too many trifling cases were being written, that our strength should have been conserved for better things."
It's quite a condemnation of the kinds of matters that they've had to deal with. When did Chief Justice Taft first have the idea of the Judiciary Act of 1925? I mean, you've outlined his an evolution of sorts, but did he have a specific act or legislation in mind, and when did that emerge? And then after you respond to that, Robert, I would ask Dan his interactions with Congress in that regard.
So he had ideas that we had to protect the Supreme Court from this abundance of trivial cases, that you ought to reserve the time of the Supreme Court for important cases, as he said, to provide guidance for other members of government and for the general public. That was his conception of the Supreme Court. And he articulated that in various ways with various criteria from the period 1905 until 1921. I do think it can be shown that he enters the court with an agenda of 3 major reform items. The first is what will become the Judiciary Act of 1922, which creates the Judicial Conference and allows judges to be transferred from districts which have too little business to districts which have too much business. The second is something he never gets passed through Congress, which is to enable the Supreme Court to create rules of procedure for common law cases. That doesn't happen until the 1930s and the death of John Walsh, who was Taft's enemy. And the third is what we now call the Judiciary Act of 1925. And we know this because in December of 1921, he's appointed in June 1921, he gives these as the three major items of his agenda. And we know from correspondence, we can piece together the fact that he gets on the court in June of 1921. He appoints a committee of two people, William Day and McReynolds. Day is a Republican, a very prestigious Republican, Secretary of State, and McReynolds was a Democrat. He was Attorney General under Wilson, so he's got the politics covered. He appoints this committee to create something like the Judiciary Act of 1925 to begin to draft it. And this goes through several iterations, and it goes to the conference of the Supreme Court sometime in December of 1921. And at that point, we don't have the exact details. William Vandervanter, who's a supreme drafting genius on the Supreme Court, takes over the drafting of the statute, and we think he completely revises it so that by early January of 1922, there's a more or less complete draft of what we now call the Judiciary Act of 1925 in place on the court that can be shown around to various people, like, for example, Solicitor General James Beck, and also the chair of the Senate Judiciary Committee, Albert Cummings.
And Dan, could describe for us the interaction with Congress on that, and who in Congress took a lead on it, and how was it received, and who was an advocate for and against it?
Yeah, it's important to note in a way that people wouldn't really think today that Taft was not shy about getting involved in the nuts and bolts of legislating when it came to the courts. As Robert said, he was corresponding with Albert Cummings, who was chair of the Judiciary Committee. He was corresponding with other senators who presented some objections and criticisms of the bill. He was testifying before committees in favor of his Conference of Judges, the Senior Conference of Senior Circuit Judges, and the bill to allow the Supreme Court to write its the rules of civil procedure for the whole federal judiciary. And in doing this, he's doing this at a time when the Supreme Court is not particularly popular. It's facing a lot of criticism from progressive members of Congress who are angered at their perception that the court is, ruling on important cases of public policy in a way that is limiting the government's ability to meet modern challenges of, an industrial economy and society. And yet he feels comfortable being involved. He's so involved, he starts sending notes to he writes letters to the Republican leader in the Senate, Henry Cabot Lodge, asking him to put his favored senators on the Judiciary Committee because he thinks, that there's a couple of progressives on that committee, George Norris and William Borah, who he doesn't consider to be Republicans at all, and he's angered by their ability to step in. And Lodge very politely declines and says, "We're not going to do that. Thank you, Mr. Chief Justice." But yeah, so it's really him taking the lead here. Albert Cummings becomes a really important partner in this case. Interestingly, he started out in the Senate as a progressive Republican, kind of bucking the, being an insurgent, bucking the old guard of the Republican Party. By the 1920s, he's becoming much more comfortable with kind of like the main line of Republicans, is open to hearing from Chief Justice Taft in order to work with him on getting this agenda through. And I could talk a little more in a bit about who some of the opponents were, but he does have a a legislative partner on the Senate Judiciary Committee that really helps bring this through.
It's a remarkable involvement of a Chief Justice to get that involved in legislation. Of course, it affected directly the court, and so he had an obvious interest in it. But to get that involved in the detail of the drafting is certainly highly unusual. Historically and in the present day, it's unheard of. But was it criticized at all at the time, or what was there any public scrutiny of it, or reaction in media or elsewhere about it?
So very interestingly, it's kind of amazing in retrospect how quickly they were able to move on this legislation once it was in its final form. As Robert noted, the bill was more or less drafted in 1922. The Senate holds hearings, a subcommittee of the Senate Judiciary Committee that Cummins is on himself, holds hearings on it in 1924. The House holds its hearings. Justices of the Supreme Court, Van Devanter, McReynolds, and Sutherland all testify. And it moves its way on the House floor very quickly. There's almost zero discussion or debate on the bill in 1924. There's a little more debate on the bill on the Senate floor, which is kind of interesting. And the main objections get raised by a New York senator by the name of Royal Copeland, who is essentially acting as a mouthpiece for New York lawyers, who he says are telling him, we're not that comfortable with some cases becoming final in the courts of appeals. We believe that, all cases should have an ability to be heard in the Supreme Court. And the other opponent who opposes all kinds of Taft ideas during this time is Thomas Walsh of Montana, who is a lawyer himself, but is always kind of looking out for like the small litigant. In his view, he's the one who basically puts the brakes on the court getting the civil procedure writing power, because he says it would not be fair to small town lawyers who sometimes cross state lines. This would be a mess. It'll take too much power from the bottom up in the judicial system. And he is kind of a thorn in Taft's side throughout all of this. The other really interesting thing is, so why isn't there a lot of pushback? There's a real deference to the court itself being the writer of this legislation, that it has the benefit of their expertise, and us members of Congress really shouldn't mess with this. At one point, there's a proposed amendment on the Senate floor, and Cummins basically says, this bill was written by the justices themselves. I don't think we should mess with it. It's perfect. They know what they're doing. We should stay out of their way. Oh. And this is, I think, a really important trend that takes place in the 20s and 30s dealing with the court. The reason why Taft could walk around and call himself a progressive, because he's talking about expertise being brought to a legislative problem that is more important than taking it away from the politics, right? The rank politics that you get in Congress. And so I think this is really important. This also comes through in the Cummins subcommittee judiciary report about the bill, where they say to, presumably to the rest of the Senate in reporting it, there's expertise here. What's really important here is that we're taking something very complicated and making it very simple. And yet, at the same time, it's so complicated, we shouldn't mess with it.
And leaving it to the expertise of the judges and justices. It's an unusual display, certainly in our day and age, of comity, comity, not comedy, but comity among the branches. And the only thing I can think of in more recent history than this act would be the Rules Enabling Act, in which Congress gave delegated authority for the courts to come up with rules of procedure, because they had the expertise to do so.
The only reason they enacted the Rules Enabling Act is that Thomas Walsh died. Thomas Walsh was asked by Roosevelt to be his Attorney General. He dies, and therefore they can get it through the Senate, because otherwise it never would have gotten through the Senate.
Interesting.
But it's also, you should note that there are important changes to the bill made at the last minute at the insistence of Walsh in the Senate. There's interesting correspondence between Brandeis and Frankfurter. Brandeis says, I hear that these changes were made, but since Van de Vanter approved them, I assume that they're okay. They're kind of like they expand the number of cases that can come as of right to the Supreme Court. They're very technical, and they're very technical because it turns on the definition of what a statute is as opposed to the application of a statute. Very interesting history to those changes that Walsh puts in. But internal to the court, there is this constant reminder by Van de Vanter every time he writes to a friend, but most importantly, every time he writes to Taft, he says, remember that we drafted this bill at the request of Albert Cummings. It turns out it's not true. It turns out that they presented it to Cummings, but Van de Vanter was extremely sensitive to the accusation that the court will have initiated it and drafted it. Mm-hmm. And so the public presentation was always by the court, and in fact by the Congress, that this was done that the justices drafted it at the request of Congress. But Congress could never quite get their act together. Some people in one Senate report, it says it was done at the request of the ABA, and at others it was done, at the request of the Senate. So there was a lot of finger pointing. The truth of it is that Taft came in and he did, as you pointed out, a lot of lobbying. He created many, many different bills, which he pushed on the Senate and the House. He was very close to them and got them passed. And this is an example of it. But just to give you some sense of how extraordinarily interventionist he was, there is a Senate bill pushed by a guy named Caraway, who was the senator from Arkansas, that would deprive federal judges of the right to comment on evidence in jury trials. Taft thought this was an abomination. And there is in the Taft papers a memorandum that he wrote, showed only to Van de Vanter, saying that this proposed statute was unconstitutional. So it was a flat out advisory opinion. He showed this only to President Coolidge. He showed it to Harlan Stone, who was then Attorney General, and he showed it to Nick Longstreet, who was the Speaker of the House, and he got it killed in the House with this flat out advisory opinion that didn't even have the imprimatur of the rest of the justices. And he felt confident enough to do this as to leave it in his papers.
And he was very savvy, right? So the other, I can't remember who initially during the lead up to the 1925 bill, there's a suggestion that Taft go and do some testifying because he says actually, being aware of the polarizing nature of his reputation in some quarters, says I actually think that it'll be better if I take a step back and let the other justices do this instead of me. I think I would do more harm than good in the eyes of lawmakers.
It's all fascinating and certainly a different environment in those days than currently. And adding to that environment, where was Professor Post? Where was Taft located at the time he was engaged in all these activities with Congress, physically and at the court?
Technically, he was located at home. I mean, there were no chambers for. There was chambers for only 2 or 3 justices within the Capitol, and these were in little holes in different places.
The court met in the basement of the Capitol up until 1859, when the Senate moved to its new chamber in the expanded portion of the Capitol, and then the Supreme Court moved upstairs to the old Senate chamber. What we now today, when we show tours, we call it that's on the first level, and they call that the old Senate chamber, but it was also the old Supreme Court chamber for many, many years. One thing I like to point out about that, in addition to what Professor Post said, in terms of just the lack of facilities for all the staff related to a 9-person court and with their administration, is that you can get a sense of how popular or not popular the court was at this time, because when the court moves in, when the Senate was in there in the mid-19th century, they built new galleries along the curved wall because it was becoming so popular for people to come and watch the Senate orators speak. And when the Supreme Court moves in, they take them all down. They're not particularly interested in hosting an entire crowd of people into those cases. And based on the kind of cases that Professor Post described before, no kidding, nobody wants to come and listen to all these cases. These aren't always important discussions of in big important principles and that kind of thing.
The caseload was very different. That's right.
But
You mentioned,
the technical answer to your question is there was a conference room where they would meet. It was
yep.
across the hallway from, I stand corrected, the old Senate chamber. And when Taft received a visitor, he would have to do it in this conference hall, which was technically the property of all the justices, not of the Chief Justice alone.
You mentioned his interaction with President Coolidge. What was his relationship like with President Coolidge, and how did he get him on board in supporting the Judiciary Act?
Well, Taft is appointed by Harding. Harding is an Ohio politician. Taft is an Ohio politician. Mm-hmm. Harding nominated Taft in the 1912 convention. Harding was extremely close to Taft. He called him the Big Chief, and called him in right before he actually became president and said, look, I'm going to appoint you to the court. And Harding always viewed Taft as kind of like the elder statesman. Taft had acquired enormous prestige and bipartisan prestige in the period after his presidency. He was roundly defeated in 1912. He carried only 2 states. And after that, he became a very popular lecturer throughout the United States. But he did 2 things. One, during the war, he became the co-chairman of the War Labor Relations Board with a very active Democratic person as his co-chair. And he created fair labor standards for American workers. He forced employers to recognize unions. I mean, to stay with the unions they had already recognized. He equalized the pay of men and women. He did a lot of things which established his relationship with labor, which previously had been very sour. And then when Woodrow Wilson wanted the League of Nations, this was viewed as a very partisan issue. And Taft was one of the only Republicans that was willing to go on a speaking tour with Wilson, for example, in Carnegie Hall, and defend the League of Nations, for which, for example, someone like Hiram Johnson voted against him. The irreconcilables would have nothing to do with the League of Nations. 4 of them in the Senate were the people who voted against Taft. But this gave him a very bipartisan reputation by 1921 when he's appointed. So he comes in with this enormous independent reputation, with this tremendously close relationship to Harding. He was in Harding's office 4 or 5 times a month, talking through matters dealing with the federal judiciary, who should be appointed, who should be U.S. attorney, what sort of bills Harding should push. And he inherited that relationship with Coolidge. He started out being very, very close to Coolidge. He would talk to him continuously. He got Coolidge to recommend the Judiciary Act of 1925, both in 1923, his annual message, and in 1924, his annual message. Coolidge began to distance himself later from Taft as Coolidge began to find it harder and harder to get his judicial nominees through the Senate. And Taft was pushing for non-political appointees, what he would regard as non-political, meaning people who were very conservative on the Constitution, whereas the Coolidge was trying to appoint people who would get him the favor of senators so he could get his bills through the Senate. He had a very narrow majority of Republicans in the Senate. And so relationships between Taft and Coolidge began to cool over the appointments process, say late 1926, 27, 28.
You mentioned too, Robert, the enlistment of the ABA at one point, that Taft was engaging other outside interests so that it wouldn't look entirely coming from his desk, or and then getting other justices involved. Talk about the role of the Solicitor General and how Taft enlisted his help as well.
Well, to begin with the ABA, just to give you some sense of how well connected Taft was, the chair of the ABA's Committee on Jurisprudence and Law Reform, which was the relevant committee here, was Henry Taft, who was Taft's half-brother, and later become, Cadwalader, Wickersham, and Taft, that law firm. That's the Henry Taft. That's Taft's brother. And the ABA was originally proposing, as Daniel was talking about, increasing the number of justices on the court. And Taft writes him a letter saying, don't do that. Nobody up here wants that. Can you imagine if Democratic presidents could appoint these justices? It would be dreadful. So what we want to go is the search thing. And Henry turns around the ABA and gets the ABA to come in on behalf. Also, one of Taft's very good friends, a guy named Thomas Shelton, a Southern law reformer, and who does anything Taft wants, and Taft gets him to testify in support of this bill. James Beck is the Solicitor General. He's very conservative, very well published man. And he is also for appointing more justices. And Taft calls him in and said, he basically calls him in and gives him a hiding and said, "Don't you dare do this." And Beck backs off and then testifies in support of the ABA rule. Although from the correspondence, he still thought personally it was the better thing to do, but nevertheless he would support what the court wanted. So he came out in favor of the judge's bill. So I mean, Taft, virtually anyone who was anyone in Washington, D.C. was connected in some very deep way with Taft, and he could play, as Daniel said, all of these cards like an organ.
I have to say, I'm from Hamilton. I grew up in Hamilton, Ohio. Family's all from Kentucky, but most went up there for jobs. And they named our schools in Hamilton after presidents. I went to Harding Junior High School and Taft Senior High School. So it's all coming back to me now. Dan, tell us about the climate in Congress. When at the time, we've talked a little bit about that, and who on the Senate Judiciary Committee, which members supported them, and who opposed it, and then let's talk a little about the actual mechanics and process of the legislation moving through, and when Taft testified before Congress. We want to cover that as well.
As I mentioned earlier, and Robert alluded to, the Republicans are in the majority in the mid-20s, but the progressive Republicans, a small group, they had come up as from the 19-teens, being objectors to the League of Nations and things of that sort, commonly associated with the farm bloc, agricultural folks in the Midwest, have a really important role to play, and they are really a thorn in the side of mainline Republicans in this period, where they are able to kind of gum up the works at the end of every session of the Senate in this era with filibusters and the like. When it comes to, I think also there was a lot of deference paid to the Judiciary Committee in that way. And the support for the bill ultimately becomes bipartisan, despite kind of the usual objections of Democrats over the previous generation to aggrandizing the federal courts. So alongside Cummins on the Judiciary Committee, you have Lee Overman of North Carolina, who was, an old school white supremacist Democrat from the South, but he serves on this subcommittee of the Judiciary Committee, and he supports the passage of this bill as well. The real opponent, like I mentioned earlier, is on the committee is Thomas Walsh for the some of the things that I mentioned before, and then but once the bill makes its way to the floor, there's really very little full debate about it. It's interesting that one of the objections from I forget exactly, I think it was Royal Copeland of New York saying, there's this discomfort with the circuit appeals courts becoming, final in a lot of cases. Cummins says, you really shouldn't worry about that because we can rely on the patriotism and intelligence of the court to decide what to allow or hearing and what is really important, right? So there's this trust on his part and on those who support him that you can impart this discretion and this authority to the court, and that they will use it wisely. And so really, you don't have to worry about it in terms of jurisprudence. This is really about administration more than anything else.
I should add to that Thomas Walsh had been able to block this bill in previous sessions of Congress, just because he was such a powerful senator on the Democratic side. But he was unable to block it in this session because in February of 1925, he had just lost his battle opposing Harlan Stone's confirmation to the court. So he had led this huge fight against Stone in the committee. He had lost it. He'd been overwhelmingly defeated in the Senate, and he just didn't have the stomach to take on two battles at one time in 1 month over the court. And that's one reason that this bill passes through the Senate when it does in 1925.
Interesting. Why were he and Taft so at odds? Was there a particular incident that?
Yes, because no, Thomas Walsh was Taft called him a jury lawyer. He loved to play to juries over judges. Taft, like Holmes, really did not like juries. He liked judges. He liked rules of law. He thought that he was a plaintiff's lawyer. He thought Thomas Walsh was a plaintiff's lawyer who liked to milk the corporations, the railroad corporations who had accidents, in Montana, and Taft identified with the corporations. Taft was very much for a national market, which means supporting national corporations. And this goes to the point that Daniel had raised earlier about diversity cases. It was a major platform for Republicans to have a federal common law that was very corporation friendly. And that's why diversity jurisdiction was so important. These are the days before Erie, when federal courts would decide diversity cases on the basis of federal common law, not state law. And Thomas Walsh was opposed to all of this. In point of fact, in 1922, when the first version of the Judiciary Act is unveiled, Thomas Walsh gives a lecture in Virginia opposing the proposed statute by saying the way we should fix this is get rid of all diversity cases, because he really didn't like them being channeled into federal courts, which he viewed as defendant-friendly, corporation-friendly, national market-friendly, and so on. And there is one justice who opposes this act, only one that we can know of, and that's Brandeis. Although Brandeis authorizes Taft to say the court as a whole supports it. Brandeis himself says, I authorize you to say that, but I myself don't think this bill will work. And Taft turns around and writes Vandevanter, who was his closest confidant. My guess is that because Walsh opposes this, Brandeis also opposes this.
Interesting. But Brandeis didn't publicly oppose it.
No, he did not.
And it is, just to add on to that a little bit, right, to bring it back to that late 19th century debate, right, how durable that discussion was, right, that the problem of the federal courts is that the federal courts are distant and expensive, right, and that they're being used by the large corporations to take small litigants further and further into litigation, and it's making justice difficult for them. And, the extent to which that just doesn't break through. I mean, there's like changes here and there in terms of like the amount of the cost in dispute maybe was raised here and there. It's raised in the late 1880s, which is one of the reasons why you get the Everett's Act comes through, because at least they took some step. I think they raised it from like $2,000 to $5,000. And so then there's this idea of like, okay, we've at least addressed that. The Democrats who had opposed any tinkering with what the court looked like in its jurisdiction, they will now come on board and say, okay, we can do something about this. But that issue just doesn't go away into the 1920s.
It's an interesting juxtaposition, though, too, because Taft was for access to the courts. I mean, in the sense he didn't want it to be too expensive, although he may have had corporate interests at heart in his practice and some of his policies. He still wanted to make the courts affordable and provide access to them, notwithstanding the workload that the Supreme Court itself had.
So what's so interesting about Taft and his ideas going back into 1905 and after is there's all of this groundswell against an overreaching Supreme Court. The Lochner era is upon us. The court is taking its power unto itself to strike down laws, and it's very unpopular. And Taft says, well, the real reason it's unpopular is because of all of this inefficiency. Yeah, right? He tries to change sort of tries to steer the discussion to where he wants to put it, in which case he's saying, no, we want the federal courts to be open, but when people get here, we can make it cheaper and more efficient, and then we can blunt a lot of this, this criticism of the Supreme Court and the federal courts in general.
Well, it leads me to the next portion of our discussion I hoped to get into, and that was Chief Justice Taft's interests in administration of justice and the administration of the courts. And Robert, I was going to ask you about Taft's efforts in lobbying for building the court. We've touched on that earlier about the needs for it and where the court was located in the in the Capitol building, and the justices really not having chambers or offices themselves. So let's talk a little bit about that initiative. And in addition to the physical structure of the court itself, let's talk about the administrative structure that Taft ushered in.
Well, on the court itself, Taft always felt that they needed a new building, but he thought it was hopeless to get a new building. So he really didn't do much about it during the first couple of years he was Chief Justice. And then something really, you should also know that Taft creates the building commission in Washington, D.C. about where these are going to be placed. So he is very much concerned with the outline and the placement of great Washington buildings. He himself supervised the Lincoln Memorial. I mean, that's a Taft production, the Lincoln Memorial. We know that during the first couple of years he was Chief Justice, although we don't have the drafts available to us or any of the correspondence, he got Bacon, who designed the Lincoln Memorial, to do drafts of a Supreme Court building, which is quite fascinating. So it was on his mind, but he couldn't do anything about it. And then Stone gets appointed, and he joins the court March 1925. And what's really interesting, and within a month, Taft has the court take a vote about whether they should get a new headquarters. They should build a new courthouse, and it's 5-4 to get a courthouse, which tells you there was 5-4 the other way before Stone had joined the court. And the reason Stone was so adamant about this is that he couldn't get satisfactory chambers at the Capitol. He kept getting Senator Keyes, I think, from New Hampshire, gave him some committee room for use, and Stone says, "Oh, the light is not right. I can't bear this, and I don't have my home built. So I don't have a library. What am I going to do?" And he's kvetching to Taft like constantly. So Taft takes him aside. Well, maybe we should get a new court building. So he gets his vote, and now immediately upon getting this vote, he writes Smoot, who is in charge of the building project within the Washington, D.C. And he says, you ought to appropriate money for a new court building. And Smoot says, no, I'm authorizing this huge, I think it's in the hundreds of millions of dollars, building project for Washington. This is right post World War I. And Washington is feeling its oats. And all of the discussion of it is like the Emperor Augustus, who found Rome brick and left it marble. That's the way Washington is thinking of itself. It's now the new capital of the world. Washington is now the most powerful country in the world. After World War I, Europe has destroyed itself. And so what's left standing is Washington. We deserve to be marble. And so there's this huge, in the parsimonious Coolidge administration, there is a huge building project to remake Washington, and Taft says, this is our ticket to get a new Supreme Court building. And so Smoot said, no, I'm not going to put it in the Senate bill. And Taft, being really smart, says, okay. And then he goes there was a conference committee because the building project bill was different in the House and in the Senate. Taft goes to the conference committee members. He goes right around the Senate, and he gets the conference committee members to put it in the conference bill. It wasn't in either bill. He got them put into the conference bill. So it comes back with an authorization for a new Supreme Court bill, like unheard of. But he's very sophisticated. He knew exactly how to do this. And then he had to go through the stages of getting land condemned. He had to condemn the headquarters of the Women's Party. So Taft considered it of importance for the court to have a new home, not merely for the prestige of a new home, and not merely for the convenience and the chambers for the justices, since most of the justices worked at home during Taft's period. And in point of fact, most of all of the justices did not inhabit the court, did not move into the court until the late 1940s. What he felt it to be important was for the court to have the administrative apparatus and the room for the administrative apparatus to house the marshal, to house the clerk, to keep the files, to allow the Solicitor General to have an office, to have litigants have an office, to have conference rooms for the court to meet. That's what he felt to be the essence of having a new courtroom was. And that was really the way he regarded the judiciary, first and foremost, as needing the bureaucratic prerequisites of a functioning branch of government, which it did not have really before Taft became Chief Justice.
Thank you very much for that, Robert. And I would just add to that and his enormous accomplishments in this regard, that is to the administration of the third branch of justice, third branch of government, I should say, and that was the establishment of the Judicial Conference of the United States. Not a lot of people realize that prior to this era in the court's history, the court was the judicial branch was not administered by anyone really within the judiciary itself. Originally, the Department of Treasury oversaw the administration of the courts, and then in 1849, the Department of Interior took over that responsibility, and then in 1870, the Department of Justice oversaw the administration of the courts. And so it wasn't until 1922 and under Taft that the courts began to administer themselves and set their own policies and to represent the judiciary's interests before Congress with regard to its budget and come up with its own processes and procedures. That was a huge development for the independence of the judicial branch, and as the courts and the federal courts workloads grew, that was essential. Dan, you were going to.
Yeah, I was just going to add. When I used to work at the FJC, I used to tell people before the 1920s, the federal judicial system was barely a system, and it was not. It was obvious to district court judges at this time that this meant important change. Some resented the idea that the Supreme Court and the Chief Justice would take a hand in maybe disciplining when it came to maintaining regularity with their caseloads and that kind of thing. The full idea of power that Taft wanted initially when he created the conference of the Judicial Conference and being able to reassign judges throughout the nation. He didn't quite get as much power there as he wanted to because of the reluctance of members of Congress and district judges for him to have that kind of say. So it really was, I think, recognized at the time as a really important difference in how this was going to work.
And it certainly has proven to be the case going forward in our history. Let's talk and conclude. I'm sorry. Go ahead.
One thing quickly to add is, Taft was the one and only justice who was president of the United States. So he was used to administering a branch of government. And when he became Chief Justice, he imagined the judicial branch as a coherent branch of government, just as he had imagined Article II as a coherent branch of government. And he created administrative mechanisms that mirrored executive administrative mechanisms. So today, the Chief Justice gives the state of the judiciary. Well, that's patterned directly after the State of the Union, which Taft gave as a president. And this is how he imagined the Chief Justice as the administrator in chief of Article III, just like he had been administrator in chief of Article II.
It's fascinating, Robert, because what he designed and what has evolved within the judicial branch itself is almost a microcosm of all three branches of government. I mean, within the Judicial Conference of the United States and the Administrative Office of the United States, you have executive functions executing the policies and legislative functions almost out of the Judicial Conference committees that are drafting policy for the branch, and even judicial functions within the judiciary itself and on hearings and so forth with regard to conduct issues and in the branch. So the administrative functions and you point out very wisely how Taft drew upon his executive experience as president to make the judiciary more efficient and to insert into its operations executive functions for efficiencies and self-governance and independence. And I thought we might just conclude with observations from you, Robert and Dan, about the ultimate results and long-term consequences of the Judiciary Act of 1925 and in what ways the court may have changed and the courts may have changed since then in the way of being final arbiters of judgments and settlers of disputes. And then in terms of separation of powers, how important this act is in our history?
Well, the first thing to be said is that it was spectacularly successful in allowing the court to control its own docket. I mean, the court very rapidly became the court that we now know, in which you argue a case and it's settled in the same term, it's decided in the same term. You couldn't have done that without the Judiciary Act of 25. So it creates the pacing and the self-control which the modern court exemplifies. So that's the first point in that way. But the act has had many unintended consequences, the most important of which can be described in the following way. Uh, Courts in the United States and in most common law countries have two functions. The first function is to decide disputes. Every society has a lot of disputes. They have controversies, and they need an institution that can settle it by a third party coming in and speaking to the two disputants and saying, "You win, you lose," or "This is how we divide the case." That's the origin of the institution of courts in common law countries. And a second function of courts is to declare the law going forward. Courts in common law countries are permitted to make law because everyone understands that that's necessary in order to settle disputes. You have to make the law that settles the disputes. We want disputes settled according to law. What the Judiciary Act of 1925 did, and no one foresaw this, but it was deep within the structure of the court, of the law, is it separated these two functions. Because now the court could choose which disputes to settle, which means it could set the agenda for lawmaking in the United States. It could say, I'm going to address the question of school desegregation, and I'm going to concentrate my dispute settlement in this way. And everyone understood this to be saying, well, the court is settling these disputes, but it's settling these disputes in order to create law. In point of fact, Vinson, by the 1950s, Chief Justice Vinson says, whenever you get a case, cert is granted, you are, in effect, representatives of a class. You're making law for the class of people for whom you are a representative dispute. And by the time we get to Earl Warren, he is explicitly defending the function of the Supreme Court to set the agenda for constitutional law in the United States. It's the Warren Court which first fully internalizes this distinction which the Judiciary Act puts on the table between lawmaking and dispute settlement. Everyone understood from the outset that the court, because of the Judiciary Act of 1925, was becoming a little bit more like a ministry of justice, that the disputants who were before the court were, as it were, standing in for everyone else who was in a similar position. They would become transparent to the lawmaking function. They understood that theoretically, but practically it did not come home until the Warren Court began to set very important agendas for the development of constitutional law in the United States. And that's one reason why the Warren Court became so controversial. The irony is that the present Supreme Court is staffed by justices who grew up rejecting Warren Court jurisprudence, root and branch. They reject much of what happened during the Warren Court. They're originalist. They don't want to have the living constitution that the Warren Court celebrated. But what they have accepted is the understanding of the role of the Supreme Court, which the Warren Court pioneered. They understand, the present court understands itself to be an agenda setting for the development of constitutional law in the United States. It's doing that, for example, with respect to Article II powers, with respect to the unitary executive, and so forth and so on. It's very clear that the court has an agenda with regard to these things, just like the Warren Court had a different agenda. So while the substantive law has changed, the role of the court, which the Warren Court pioneered and was made possible by the Judiciary Act of 1925, is reproduced in the present Roberts Court.
Thank you very much, Robert, for your observations. And would you like to add, Dan, to your take on the importance of the act?
I think, what I would comment on is, it's noteworthy that we're celebrating the 100th anniversary of an act of Congress that had such important ramifications for how the Supreme Court functioned and functions today. And I think it's important to keep in mind that throughout American history that these issues evolve about the court and about the Supreme Court, whereas today there seems to be this idea that there's a there's this major distinction in that Congress doesn't have necessarily a role to play in a lot of areas related to how the courts work. From up through the into the mid 20th century, I think there was much more comfort with the idea that Congress had an important role to play in shaping court jurisdiction, court organization, administration. That these questions were not just legal or technical, but that they were in fact political. And I think one of the results of, I think this comes maybe after Taft's time, Franklin Roosevelt and his very blatant attempt to use the language of administration to make a very big political change when he proposed packing the Supreme Court at the end of the 1930s. The only thing that comes out of that is the AO, by the way, right? The rest of the plan loses, but a couple years later, the Congress turns around and says, actually, there was a good point there about administration. We should get that part. But so I think just looking back at the history of this bill and the changes that happened during this period more broadly, just people keep in mind the way that Congress does have this important relationship with the judiciary, even as it's carved out more ways to be independent as a branch of government.
Very, very well put. I want to thank both of you very much for your time today and joining us at the Society and addressing and celebrating such an important piece of legislation for the judicial branch of government and the Supreme Court. We're honored that you joined us. I can't think of two more informed people on the topic from both the judiciary standpoint and the Congress's standpoint. So we're very grateful. Thank you both, and we look forward to future programs together.
Thanks, Jim.
Thank you, Jim.